This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why, if there is no written agreement, a claim to be an additional insured of a policy of a vendor doesn't work, and failing to understand the contract it wrote cost the Chicago White Sox. The Chicago White Sox Limited et al. And State Automobile Mutual Insurance Company, the insurer for defendant We Clean Maintenance and Supplies, Inc., disputed whether the White Sox were additional insureds of We Clean's policy with State Auto. After a patron was injured at a White Sox game, he filed a lawsuit against the White Sox plaintiffs, alleging that State Auto had wrongfully denied coverage. The circuit court granted summary judgment in favor of State Auto, finding that the White Sox plaintiffs were not additional insureds. In a case entitled Chicago White Sox Limited et al. Versus State Automobile Mutual Insurance Company et al., the Illinois Court of Appeals, 3rd Division, on November 8, 2023, resolved the dispute. The problem was that beginning in 2008 and continuing at least through 2012, the White Sox plaintiffs entered into a series of written agreements with We Clean, pursuant to which We Clean agreed to provide cleaning services for all home games played by the Chicago White Sox during the applicable baseball season. In 2011, while at U.S. Cellular Field, Raymond Miles was injured as he was walking down a ramp. Miles sued. The lawsuit was ultimately settled for an undisclosed amount. In 2014, the White Sox plaintiffs tendered their defense of the underlying lawsuit to State Auto, the insurer for We Clean, as an additional insured under We Clean's insurance policy. We Clean was insured by State Auto under a commercial general liability insurance policy. While We Clean was the sole named insured on the policy contained an endorsement adding as an additional insured, quote, any person or organization for whom you are performing operations when you and such person or organization have agreed in written contract or written agreement that such person or organization be added as an additional insured on your policy, close quote. No indemnification and insurance agreement existed for either 2010 or 2011. In the record on an appeal, and an affidavit from a White Sox representative indicated that the White Sox plaintiffs were unable to locate such a document. The circuit court granted State Auto's motion for summary judgment. In this case, the sole issue was whether the White Sox plaintiffs qualified as additional insureds under We Clean's insurance policy. The language of the service contract merely requires We Clean to comply with all the insurance requirements set forth by the White Sox plaintiffs and does not expressly require We Clean to name the White Sox plaintiffs as additional insureds under its insurance policy. Without a written agreement that the White Sox plaintiffs were to be named as additional insureds under the We Clean policy, there was no basis for finding that White Sox were in fact additional insureds, and the circuit court properly granted summary judgment in favor of State Auto. The circuit court properly granted summary judgment in favor of the defendant insurance company, where the plaintiffs were not additional insureds under the insurance policy, as there was no written agreement between the plaintiffs and the insured requiring them to be named as such. Since there was no written agreement between We Clean and the White Sox plaintiffs requiring the White Sox plaintiffs to be named as additional insured under We Clean's policy, the White Sox plaintiffs were not entitled to coverage by State Auto. In my opinion, reading the full policy is a requirement of everyone who is involved in inquiring or making claims against an insurance policy. The White Sox failed to create a contract with We Clean requiring it to make the White Sox an additional insured. Since it failed to include that requirement in the We Clean contract, the White Sox gave up the right to be an additional insured of We Clean, and the Sox and its insurer was obligated to defend it without help from We Clean's insurer. They should have been, of course, more accurate in the vendor agreement the White Sox had with We Clean, but since they were not, they lost out the opportunity to use State Auto's policy to defend or indemnify them to the lawsuit. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you connect, you can subscribe to the blog, and you will be advised of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe for free to the videos on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button at YouTube or the thumbs up button on rumble.com. If you're interested in further detail about insurance, insurance law, insurance fraud, and insurance claims, please consider for a very small fee subscribing to my Substack publication or my locals community. Thank you for your attention.